Welcome to the PI show. My name's Harry Nowicki. I'm a PI lawyer. I'm with a colleague, Tony Carbone, who's been a lawyer for 25 years. And we've got a special guest today, Richard Lightfoot, who, dare I say, has been an expert in the area of PI generally for 28 years.
That's correct, Harry.
So there's a wealth of experience. Tonight we're talking about the role of expert and expert evidence in personal injuries. A lot of cases are run throughout Australia and around the world, and a lot of the evidence ultimately comes down to what an expert says and what evidence comes out and what the judges accept as viable expert evidence. Richard, you've given evidence in court?
Yes, I've given evidence in court quite a few times. It is an interesting experience first up because you don't know what you're likely to be asked, but you are reliant on the requirements of codes of practice and also previous cases that outline what an expert has to provide by way of demonstrating the specialised knowledge as it relates to the field.
But you're there really to assist the court, either the judge or the jury, to reach decisions about facts?
That's correct. It's the prime duty of the expert to provide the evidence to the court. You've got to be impartial and non-biased. You've got to present that evidence to assist the court. You are there to assist the court, which is the most important aspect.
So, I think before we started, one of the memorable cases you had was things like an exploding boiler, and someone was injured with the boiler exploding, and you have to reconstruct the accident, if you like, of what happened to the boiler, why did it explode, under what circumstance, what was the cause of that accident?
Yes, well, in that particular case, the tubes of the boiler hadn't been gauged in 20 years. They used soot blowers to clear the soot off the tubes to allow heat transfer. The tubes became very, very thin, and under pressure they split and blew the fire out through the grate and hit the attendant. He was very, very badly burnt. So you had to look at that case from a perspective of where the nature of the brown coal material, also the soot blower velocities and things like that, which really related to the degree of erosion that would occur.
And it was a lack of maintenance type negligence, if you like.
Well, that's right, because it required gauging of the tubes after a period of time because of the abrasive nature of the fuel that was being used.
And you've got to explain all that, hopefully, in simple language, if you're asked to do so, to a jury.
Yes, you've got to look at a situation, try and reduce it to its simple, basic elements so that people understand the principles and the causation of failure. It's like a system of work. It's a causation and the failure that does occur. You don't wish to get really involved in detailed technological argument. If it is required, it does happen, but you want to try and keep it as simple as possible because the jury is aiming to understand so that they can then make a decision on that.
One of the problems we're encountering in court these days is the fact that more often than not, experts are getting challenged on what assumptions you're relying upon when you get out there to test something. And more often than not, as Harry said before, you've got a scenario where you've got the facts in dispute. So you're getting out there and you make these assumptions for you to go out there and do your testing. And
yes, that's right. But you've got to list your assumptions and then you've got to then test those assumptions against your observation and any other information that becomes available. One of the advantages of having experts on both sides of a dispute is that the experts then can have a concave and look at then sharing their experience and comparing and contrasting what they've been each given.
What's the chance of that happening? I mean, I don't think I've seen a case where you can get two experts in a
No,
room.
I think it's a New South Wales phenomena. Yeah,
It's a real problem. I just
They
can't-
call it hot tubbing up in New South Wales.
Well,
they all
jump
get
in
into
a
a
hot
hot
tub,
tub
do
together
Well, I think that's
and try and reach a conclusion.
well. I suppose that that's one way of obtaining information. If you can sort of put up with the heat of the oven, you might last out a bit longer. But I think they'd be aiming to get on, agree on the points they're agreeing on, then provide a report listing the points that they disagree on, and then that goes to court for the testing within
How
the
often
court.
does that happen to your knowledge?
Well,
In
I've had
Victoria,
a
that
number
is.
of cases in New South Wales, particularly when it becomes a sort of a technical argument, so that there's
About-
enough doubt one way or the other, and you've got to try and find the common ground.
What about in Victoria? Have you experienced that hot
Well,
tubbing scenario?
it hasn't occurred as often, no.
Are you trying to encourage?
Well, it is.
I think the courts are encouraging it. There's
okay.
rules that the courts are now encouraging it, but it's not often. But coming back to the sort of area, you're a consulting engineer.
Yes.
So things like failures of machinery, you could give expert evidence on. What about manual handling?
Well, manual handling, as the statistics show, is one of the major causes of injury. You've got to look at the Occupational Health and Safety Manual Handling Regulations and Code of Practice. That becomes really the Bible in inverted commas when you're doing risk assessment, because you've got to look at the accident, well, look at the potential of the accident, look at the forces involved, and then you can look at statistics and the probability of an accident occurring.
Let's give an example for the layperson to understand
Well,
manual handling.
If you look at an accident, and particularly from a perspective of manual handling, you've got four elements. You've got the height at which the lift starts, the vertical distance that the lift takes place through. Critical thing is the horizontal distance from the centre line to the spine and the frequency of the task.
So you're talking about people that are doing jobs where they're constantly
Lifting. Well,
movement.
it could be one-off, or
lifting.
it could be one-off lift, but it's there's risk assessments
Yep.
prior to a lift, plus, as you say, the all those elements involved in lifting.
Well, that's right. You've
And
got
the weight, obviously, the weight of the object.
Well, yes, you get
And-
what can be lifted on a sort of a continuous basis, but anything above that, well, the risk increases accordingly.
And is there a limit about
We've got a little
females?
break area, I think.
Is there a limit about how heavy, what weight a female can lift?
Well, there used to be, but you've got to do the assessment, and there is an element within the manual handling regulations that does bring out the requirement for women.
For women, okay. Well, look, we're going to a short break, and we'll be back with Richard after the break to talk about more issues about perhaps hot tubbing.